Good morning and welcome to Protocol's conversation on Reimagining Section 230. I'm Tammy Wincup, President of Protocol. Section 230 of the Communications Decency Act is the most discussed and often least understood law governing the modern internet. Democrats and Republicans in Washington appear ready to reform the statute, but are worlds apart on what those changes look like. And in Protocol's first tech employee survey released last week, we also learned that even people within the tech industry agree it's time for some type of Section 230 reform. That is, if they know what it is. Only 62% of our tech employee respondents said they know what Section 230 is. But of that 62%, nearly 3/4 said they agree the law needs to be reformed. I hope you will subscribe to receive all of Protocol's important reporting, including the Tech Employee Survey, that help to translate the intersection of tech and policy directly for business leaders. This is not an easy topic, so today we look forward to hosting this conversation on the future of the internet as we know it. I am pleased that our partner for this important conversation is the Internet Association. We are joined today by Dane Snowden, the new president and CEO of the Internet Association. And we're excited to hear from Dane for the first time publicly since taking on this new role. Prior to joining IA, Dane served as the Chief Operating Officer of the Internet and Television Association, NCTA. In this position, he led the association's day-to-day operations, including its policy planning and strategic initiatives. Dane, we're honored you're here with us today. Welcome.
Thank you for the introduction, Tammy, and good morning, everyone. As you just heard, I am the new CEO of the Internet Association and new to this industry, but I've been around Washington for 20 years. I spent most of my career connecting people and serving communities, and that is exactly why I'm excited about this new opportunity, this industry, and this event. Throughout my career, I worked to build a better, stronger, more vibrant America. My time with America's Promise under General Colin Powell's leadership and at the United Negro College Fund under Congressman Bill Gray's taught me firsthand the power of coming together to solve a problem. Neighbor helping neighbor to build a better community and a stronger America. At the dawn of the new century, where desktops turned into laptops and car phones into mobile phones, my introduction to technology policy began. While chief of the Consumer and Government Affairs Bureau at the FCC under Chairman Michael Powell, I was at the beginning of technology policy that gave birth to an array of technologies we see today. Technologies that are used to bring people together for shared experiences, often for entertainment purposes, but more important for education, business, social services, and emergency services. That time in government also shined a spotlight on communities that still need our help to connect. Americans with disabilities, Native American reservations, low-income housing families, and that difficult last mile in rural areas. Soon thereafter, I joined the cell phone industry, which was in the business of connecting people, at first to each other individually, and then to the world of online information and services, right there in their hands via the app-based economy. Connectivity and convenience, anytime, anywhere. And as Tammy told you, for the past decade, I've been at NCTA, the Internet and Television Association. A wonderful experience, and again, an industry in the business of connecting communities across vast portions of the United States to critical infrastructure. So joining IA last month seemed like a natural next step. With the key foundational elements of communications policy, mobility, and broadband infrastructure, this feels like the perfect union of all my experiences. And still very much at the heart of what drives me, what drives the internet industry, connecting Americans. This time, the scale of connection is not only person to person, region to region, it is the entire nation and most of the free world. Grandparents to grandkids, schools to students, artists to audiences, sellers to buyers, restaurants to diners, travel industry to travelers, and of course, cat lovers to cat videos. We are an industry that is connecting people to what matters most to them, regardless of geographic distance, social status, age, race, or education. I am proud of this fact in this industry. Today, The internet industry is such a part of our everyday lives that the genius behind all the ways we connect sometimes gets lost. 9% of Americans are connected to the internet, and 72% of Americans use some form of social media, according to the Pew Foundation. People undoubtedly find value in the services our platforms offer. They have become an integral part of life, even more so during this time of COVID. To be connected to the internet is to engage with it, whether that is emails or video calls, posts on social media platforms, memes, product reviews, restaurant ratings, and the list goes on and on. All of this is to say, people use our platforms to express themselves. We are, in many ways, a mirror that reflects our users. We are a platform for free speech, but not speech that violates laws. As the nation has grown more polarized and public discourse more coarse, some have not liked what they've seen online. For some, it is too much of something they disagree with. And for others, it's not enough of what they agree with. We are a country in a period of reflection. We are a rebalancing society. We are reviewing our history. We are looking for a future that is better for all. The internet reflects this time of transition and empowerment. The internet is a reflection of us. So this year marks the 25th anniversary of Section 230, which should be reason for both celebration as well as a healthy conversation about what has worked and which points, if any, might be improved. We invite that conversation. Rather than being at hearing tables, we want to be at conference room tables, proactively engage with policymakers, working together to better define the challenges we seek solutions for. Section 230 flourished because of the convenience, connectivity, and community Americans have found through it. History has shown us that Section 230 has fueled a dynamic industry that is providing consumers with an array of services and opportunities. This is not simply a big tech issue. This is about leaving room for startups, little tech, and medium tech to keep growing and offering innovative new ways to make life a little better, a little easier, a little more cheerful, and connected. As we discuss Section 230, let's keep the user at the center of the conversation. Let's preserve their protections. Yes, user protections, so that soccer dads can host team blogs without being sued for angry parents' posts, so that shoppers will still have access to reviews and ratings from other shoppers, artists and small businesses access to marketplaces, unemployed the job posting sites, so that musicians and cute toddler videos can continue to brighten days with gifts and memes when words simply aren't sufficient. Post selfies on good hair days and pictures of nature to nurture our souls. Users and their content are at the heart of Section 230. It is user-generated content that made the internet and social media platforms the success they are today. Our desire to engage with policymakers on both sides of the aisle is because we share the same goals of a safe and open internet. We want an environment where children and families are safe online. We want an online community that is civil and respectful. It is not in our best interest or in the interest of our business models to hold a bias or to allow our service to be overrun by bad actors. It is my hope that we can begin a dialogue and balance the competing mixed messages of stop big brothering versus start parenting online. It is as much of a no-win situation as moderate more, moderate less. Let's meet, let's talk, let's find a way forward. It is that willingness to engage that will be a hallmark of the Internet Association under my leadership. It is the reason that we are sponsoring this event with Senator Warner and the panel to follow. Let's start the conversation now. Let's connect. Thank you.
Hi, thank you so much, everyone, for joining us. We are really pleased to have Senator Warner here to discuss his Section 230 reform proposal, the Safe Tech Act, as well as other ideas that are on the table. So if you have any questions for Senator Warner, you can tweet them with the hashtag protocol policy on Twitter. So let's dive in. Senator Warner, there's been so much debate in Congress over reforming Section 230, and every lawmaker seems to have their own idea. So why do you think your bill is the best approach?
Well, Emily, thank you, and let me welcome Dane to this wild internet world. He comes from the cable and wireless world, those worlds I was involved in before I was engaged in politics. And I'm glad we're going to have this debate. There are very few things in Washington that seem to unite us these days, but we have, in the case of Section 230 reform, calls for Section 230 reform or elimination from people that range from Donald Trump to Joe Biden to a really kind of interesting thing where we even see Facebook in the last few months starting to acknowledge that maybe Section 230 reform has finally come. And I say that with the sense that, as somebody who can remember the late 90s, I was involved in telecom, the beginnings of this industry. And the idea that Section 230, which was well-intentioned at its outset as being a tool to give to this emerging industry of content providers, online platforms, who wanted to do a little bit of self-moderation, well-intentioned, to basically see that evolve into this almost blanket immunity or get out of jail free card for large online providers to do nothing for foreseeable, obvious, and repeated misuse of their platforms, I think have finally brought around this ultimate coalition to say the time has come to make some changes. And what we've done in the Safe Tech Act, and I say a Safe Tech Act that has been part of an iterative process where we've been out consulting with interest groups, experts, many of you on this panel, for months and months on end to try to get this right. And I feel like in terms of our initial positioning, as someone who didn't go back out to try to change the actual words of Section 230, that some have said our bill does not go far enough. Others have said it goes way too far. I think we start at the right point. And I know you've got a number of questions, Emily, but let me make sure I make clear what we do and what we don't do. This legislation does not restrict anyone's right to free speech on Section 230. As Dane indicated, I want that soccer dad to be able to post whatever he wants, and I want that individual to be able to comment about the good or bad food they got at a local restaurant. What I don't want, though, are to have these giant providers continue to use Section 230 as this immunity to kind of get out of jail free card, where we've seen repeated online abuse of financial fraud and scamming done by oftentimes advertisers and paid content providers. I don't want to see the kind of collaboration that takes place amongst extremists, oftentimes violative of existing civil rights laws. I don't want to see the ability to have where irreparable harm is shown by getting injunctive relief, as we saw in the Grindr case. Suddenly a platform like Grindr be able to haul out Section 230 to prevent that injunctive relief from taking place. So what we've tried to do with our Safe Tech Act is do the following. Say that Section 230 does not give platforms broad immunity against civil rights laws. Section 230 does not give broad immunity against laws that address stalking, cyber stalking, or harassment or intimidation of any protected class, again, around civil rights. Section 230 does not give broad immunity against injunctive relief in the courts. And remember, to get injunctive relief, you have to show a higher level of harm, irreparable harm, as I think, again, the Grinder case pointed out. Section 230 does not give platforms broad immunity against wrongful death actions or suits under the Alien Torts Claim Act. And again, even Sheryl Sandberg acknowledged Facebook's culpability in the case of the Myanmar's military actions against the Rohingya. And Section 230 should not give broad immunity to profit off ads and paid content that causes direct and proximate harm. Now, we're welcome to have this conversation. We know there's probably not going to be a single Section 230 bill, but I think, echoing what Dana said, this is a legislation that served its time, but 25 years later needs refreshing and revisioning. And candidly, unless we will end up with the kind of broad across the board repeal that sometimes both ends of the political spectrum are now calling for.
Right. Okay. So you mentioned earlier that this was a long process to come up with this bill. You consulted with a lot of people, like you mentioned. We're going to hear from some of them on our next panel. Who from the tech industry did you consult with while you were writing this bill? Who's shaping your thinking from the tech and content side?
Emily, I am in regular contact, both my staff and me, and as someone who spent longer as an entrepreneur than I have as a senator, with a host of individuals on the tech side. I sit from the Senate Intelligence Committee side. We've had a great deal of contact with Facebook at the most senior levels through their Facebook government performance team. We've had ongoing conversations, frankly, with Google, although sometimes they chose not to show up at our hearings. And it's hard if you don't show up to get that kind of input. My staff has had regular contact with a number of the platform, the major platform entities, and we'll continue that dialogue. There's one thing, Emily, I think no one should be surprised about. Big tech access to Congress is pretty much unlimited. These firms spend more on lobbying. They have now become the single largest lobbying entities in Washington. So they will have their seat at the table. I do think it's appropriate, and this is one of the reasons why I think our legislation has attracted such attention. 2 years ago, 3 years ago, the civil rights community would have been more in line with the status quo around Section 230. I think the misuse and abuse that's taken place on a lot of these large platforms in a discriminatory fashion that violates the basic concepts behind our civil rights laws, and to see the broad-based support we have in the civil rights community has been one of the most major transformations that's taken place in this debate in the last couple of years, and why I think our legislation, one of the first to have this broad-based civil rights support, has really attracted a lot of attention.
And I'm sure you've heard this. There have been critics who have said, small platforms, publishers will be disproportionately harmed by some of these sweeping Section 230 reforms, even those contained within your bill. So did you have an ongoing conversation with some of those smaller platforms, before the bill was introduced? And are you open to any changes that would ensure that they are not disproportionately harmed while, Facebook just pays more that they can afford?
And Emily, I think this is one of the great indications. Section 230 in the late 90s and the authors of the legislation, I do think it was then about protecting those entrepreneurial startups. What it is transformed into is, I keep getting back to this, a get out of jail free card for the largest companies in the world to not moderate their content, but frankly, to ignore repeated misuse, abuse, in a way that we've tried to address.
Now, but Senator Warner,
let me finish. You asked me a question. Let me finish it. The question of, could there be a way under appropriate circumstances that those entrepreneurial startups get some kind of protection? That ought to be part of the debate and part of the process.
Okay, because I want to be clear to our audience that obviously we know that Section 230 is not just pertinent to the very large platforms. It's not just to get out of jail free card for very large platforms. It's an important form of defense, right, for a lot of small platforms. So I wanted to make sure that that point is clear. I want to walk through a few of the criticisms that the Safe Tech Act has gotten. So here's the first. It's a legal argument that basically people use to talk about a lot of these bills that create carve-outs for certain types of speech. And they say that, speech is a lot of that speech is protected by the First Amendment. So if you get rid of Section 230 protection, you are still left with First Amendment protection. And all you've really done is take away that fast track for the companies that would use Section 230 protection in court. And to Emily's point, the large companies, and to your point, Facebook, they have the money and they have the lawyers to mount these First Amendment defenses. The smaller platforms and publishers, by and large, do not. So what do you say to that criticism?
All right, go ahead. Well, first of all, we don't, there have been a number of efforts that have said, let's just get rid of Section 230, let's call the platforms publishers. I think there's sometimes a whole questions around, we don't go at defamation, we don't go at changing those standards. We don't frankly go at the free speech component of Section 230. What we have said is that, and we all know in the last 25 years, independent of this whole debate, there have been major reforms, tort reforms, the ability to bring cases in lawsuits have gotten dramatically harder. And what we've now, and what we've seen though with Section 230 is that the courts have expanded this, what I think was potentially originally good intent, so broadly that companies can use this as an ability to dismiss suits before they even get to the pleading stage. We're saying let's take areas where for the most part, which are already illegal, such as civil rights law protections, and say Section 230 should not be a preclusion on that. Let's take an area like injunctive relief where there was already a higher legal standard. You got to go to the court and show irreparable harm. You should not be able to use Section 230 to say, well, we're not even going to look at that to determine whether that irreparable harm exists. I think we've tried, and if there are ways to improve upon this, we've tried to thread this needle, I think, in the appropriate way.
Well, there's also another part of your bill, though, that deals with affirmative defense requirements. And the idea is basically so defendants couldn't just immediately fast track to the 230 defense to get cases quickly dismissed. And this is something a lot of critics say effectively guts the main purpose of Section 230 protection. So tell me a little bit about why you introduced this.
Hold on, let's go
this
back.
Requirement.
Are you saying that the original intent of Section 230 was to, in a sense, wipe away folks' legal rights?
Not the intent, but certainly.
But you're saying, but if we're going to go back to the intent of the legislation versus the way the courts have so dramatically expanded what was potentially the original intent, I think is one of the reasons why we're having this debate. And candidly, some policymakers that may not be as familiar with the nuance and the differential between the First Amendment rights, which we want to stand by and protect, and what we think has been the now misuse of this section and the overexpansion of the court's rulings to draw it back in and to make sure that things that are already illegal, for example, illegal paid scams that take place on a lot of these platforms, I actually think there should be an ability to bring a suit against those kind of illegal scams. And the idea that you can flash your get out of jail Section 230 card up front before you even get to the merits of any of those discussions, I just respectfully think is not ought to not be the policy of the United States.
My understanding of the intent was that this was a bill that was meant to encourage, good faith efforts to moderate content, but also protect companies when they get things wrong, when they don't catch all the content or when they take something down that they shouldn't have. And obviously this law was written at a time when the internet was...
Can I just ask, are you saying that Section 230 has reinforced good faith intent on moderation. Again, if that's your view of how it's been used by the large platforms, we just have a fundamental disagreement. I think Section 230 has been used and abused by these the most powerful companies in the world to not act responsibly, and instead allow, whether it's abuse of civil rights, whether allow abuse of individuals' personal behavior, as in the Grindr case, whether it's for large platforms to say, well, I know this scam artist is paying me to put up content that probably is ripping people off, but I'm going to use Section 230 as a way to prevent me from acting responsibly and actually taking down that content. So if you don't believe those things are happening, then that's a position to have. Again, respectfully, I would just fundamentally disagree with you. Emily,
right. Well, it's not my position.
Are there other questions out there? I mean, I thought we were going to hear from a variety of questions. I'm happy to
sure. No,
I thought we were going to have.
We have some other questions, but I think it's really important to get at the criticisms that have been made to hear you answer them, in a straightforward way. And I don't think anybody is arguing that Section 230 has not been abused, and it certainly has. And we're going to discuss a lot of that. But I think when you introduce laws,
if you've got other questions or criticisms, please.
Sure. So another point of contention is that you've essentially created this provision around paid content, and it says that the Safe Tech Act would remove immunity if the provider or user has accepted payment to make the speech available. And obviously, it seems like what you're trying to get at there is speech contained within an advertisement. But there are some folks who say that looks, the way it's drafted, like it's a lot broader than that. Like it might encompass, content that's behind a paywall, or it might encompass content that is, on a platform and positioned next to an advertisement. And so I wonder what your intent was with that provision and why it's drafted the way it is.
Well, let's go ahead. And I think this will be one of the areas that as we continue through the iterative process that we've started. And again, I go back to one of Dane's comments, we ought to have this around, conference tables rather than hearing room tables. I think we probably need it around both. A conference table sometimes includes the people in the room. A hearing room table means that a company actually has to be on record defending these actions with the public able to listen. And frankly, I think the more transparency, the better. So let's go with it. Yes, the advertising content is the most troublesome. But if you have a paid site, paid content that advertises a gun market, that illegally sells, machine guns that are banned by law across the whole country, and the platform company has enough knowledge to know that that is a site, while not advertising, is being listed as selling illegal items, should the company not have any responsibility there? What's your view?
This isn't a venue for me to express my view, Emily.
Yes. So this is really interesting. Thank you. And I think it's interesting that you're still in an iterative process, open to having further conversations to see where this legislation goes. I wanted to ask you about another piece of legislation that there's a lot of energy around right now, which is the PACT Act. From Senators Schatz and Thune. Some have said it has a lot of potential to move. It's bipartisan. Facebook has expressed some willingness to elements to get behind elements of it. It's sort of a narrower, lighter touch approach than yours. What do you think of the PACT Act? Do you intend to become a co-sponsor?
Well, a couple of things. First of all, Emily, I have hope and expectation that our legislation will shortly become bipartisan, number one. Number two, I have a lot of respect for John Thune and Brian Schatz. They're both smart and informed members. And I think what they have focused on is transparency. They focused on procedural changes. What they don't focus much on is actual remedy. And at the end of the day, I doubt if there's going to be a single piece of legislation that becomes the all-telling, all-defining 230 legislation. I think there may be component parts of a variety of bills. I think that's the kind of iterative process that's out there. And again, I wouldn't doubt the fact that the largest companies in the country, and for that matter, some of the largest companies in the world, would prefer the lighter touch. But I think there are a lot of good parts of the PACT Act that I hope become law.
So you could see this process going something like people bring their different proposals to the table and you try to move them individually as a package, or sort of like, how do you see the next couple months playing out around these proposals?
Well, I think I do worry at times that the platforms, and I have had, back to the earlier comment, I've probably had as much interaction with the platform companies as any member of Congress. I go back, I think about our white paper that we put out, I think 3.5, 4 years ago, which kicked off a lot of this debate. I do feel at times that the large platforms and their agents sometimes say they want reform, but it's always last year's reform or 2 years ago's reform, and the world has moved beyond where they're at. And I think what we're seeing, whether it's data portability, interoperability issues, again, the areas where the platforms have moved, but I think that's probably not going to be enough when the rest of the world is moving even quicker than us. I say that as a macro point. I do hope that we'll see as many good ideas as possible come together. I think there'll have to be iteration. I think it's important that we not only have the platform companies and the entrepreneurial startups. I'm as somebody who's a venture capitalist longer than I've been a senator, I'm all for continuing that ecosystem that promotes entrepreneurship. Again, I would argue right now we have the opposite of that, where platforms, the large platforms, so dominate that none of the startups can actually ever get to breakthrough status. But I also think it's important that we have other voices at the table, that we have the civil rights community at the table, where we've seen a complete change of approach over the last 2 to 3 years, that we have actual individuals. I go back to one of the most outrageous issues I found in terms of abuse of Section 230. I keep coming back to the Grindr case, where an individual, a spurned lover, then took his former partner's personal information, posted it, and invited people to come and harass that individual. And no matter what that individual did to try to get Grindr to take his name down and take it off, and the level of harm that was happening to an individual, somehow Grindr absolved itself of all responsibility from Section 230. Now, I doubt if any of the original authors of the legislation thought that was going to be the outcome. So I think all of these voices need to be at the table, and we ought to work. But it is a bill. It is an area where there's going to have to be some subtlety to this, because this, my bill, our bill, is not going to get rid of all the misinformation, disinformation. It's not going to get rid of all of defamation. It is not going to, obviously impinge upon people's First Amendment rights. So there will be many in the community, particularly in the political community, who's going to say we don't go nearly far enough. And we've actually seen that with particularly some of the comments coming out of former President Trump and some of his allies in the Senate today.
So that's going to be my last question. So President Biden, during his campaign, said that he's interested in revoking Section 230. We haven't heard much from him since. Have you had any conversation with President Biden or his legislative team about how they want to see Section 230 reform move forward, or what kind of a priority it is to them?
I've had, not with the president, but I've had with part of his staff, and I think there's still a question as where the locus of technology policy is going to fall. I hope it falls at the White House. I was happy to see Commerce Secretary Raimondo, who's got a tech background herself, indicate that she also believes that we need revisions in Section 230. We'd thought about other issue approaches around, you can say whatever you want, as crazy as it may be, but do you have a really right to amplification? We thought about a policy direction that way. It didn't seem to work. We've tried to thread the needle, and again, we're open to having that conversation with all interested parties who want to get to that internet where people can express their views, but not in a way that violates people's civil rights, or not in a way that it absolves people of scamming, or not in a way that leads to the kind of death and destruction we saw with the Rohingya in Myanmar. So we're open for business, and I believe from some of the conversations I've had with the Biden team that they are interested in that kind of debate as well. And frankly, a lot of the ideas that we've expressed, I know some of the people prior to being in the Biden administration were very supportive of some of our ideas.
All right. Well, thank you so much for joining us, Senator Warner. We really appreciate you coming and sharing your ideas and sharing in this discussion. And next up, we're going to welcome our panel. So wait for them to be brought on. All right, it looks like everybody is here. Thank you all for being here. We have, just to introduce our panelists, we have Marianne Franks, who is a law professor at University of Miami Law School. We have Olivier Sylvain, a law professor at Fordham University. Lauren Culbertson, head of U.S. Public Policy at Twitter. And Daphne Keller, who directs the program on platform regulation at Stanford Cyber Policy Center. Thank you all for being here. All right, so I want to kick it off, Marianne and Olivier, with you guys, because you both consulted with lawmakers on the Safe Tech Act. So I wanted to get your insights on what you wanted to see included in this bill, since we spoke so much about it with Senator Warner, and whether those provisions made it in. So maybe, Marianne, I'll start with you.
Great, thanks so much. Hope that you can hear me okay.
Yes.
Okay, great. One of the major provisions that I was very happy to see included in the legislation was a clear limitation of Section 230 to speech. What we have seen, and that Senator Warner has made some reference to, is that so much of what has been invoked in terms of the protections of Section 230 doesn't actually deal with speech. And we get a lot of defense over how important this is for free speech purposes, how Section 230 is vital for discourse, and yet you see it being invoked for all kinds of conduct and commercial activity. And so one of the really important aspects, I think, of this particular bill is clarifying that we're not just going to talk about information very broadly speaking, but actually speech in particular. The other thing that I had really hoped for in any reform bill is getting at the concept of the Good Samaritan idea. That is, you're supposed to be rewarding certain good faith actors who are trying to limit unlawful activity and unlawful content, and you're supposed to be rewarding them with this kind of immunity. And that clearly what has happened is that everyone, whether you're a bad faith actor or whether you're actually deliberately trying to engage in misconduct yourself or get profit from it, everybody gets the immunity. And so some sense of distinguishing between the people who ought to be actually getting that immunity and those who shouldn't. I have my own feelings about the best way to do that, but there's at least this really strong attempt in this bill to say, we're going to limit it in all of these substantial ways to try to distinguish from those very, very bad actors from the good actors.
Right, so that sort of gets to what Senator Warner was talking about these online scammers that obviously we don't want to benefit from Section 230 protections, but also give those protections to platforms that are putting in a good faith effort. Olivier, do you want to talk about what you wanted to see in this bill? Olivier, I'm not sure we're hearing you.
Now you hear me, sorry.
There you go.
I was just thanking you and Emily and Protocol for having me join the conversation, such an important one. And I think you would be crediting me more if to say that I was responsible for the inclusion of this language. I think one of the things you heard from Senator Warner is that there's actually a groundswell of interest across public interest organizations for reform, and it's hardly professors making the call here. But the other point I would like to make is there are a couple. First is the turn away from the kind of I would call the fetish of upstart culture that really was driving innovation in the early years of the internet. We now have an immunity that protects, as Senator Warner said, companies that were probably not even foreseen by the drafters of the bill. So I have much more to say about this, but I think you want me to just get to the particular provisions of the statute. And so one is I'm very happy to see the what we call a carve out for civil rights and wrongful death and for what it's worth, the Alien Torts Act exception. And that's because intermediaries, pursuant to their operation of ostensibly, neutral or ostensibly passive services are actually facilitating discrimination in the ad markets, in particular. And this is important, right? This is the thing that has actually galvanized interest across public interest organizations here. Talking about the NAACP Legal Defense Fund, Muslim advocates, the Anti-Defamation League, Color of Change. I mean, this is what has excited people about this bill. And I just wanted to say something in anticipation of current people who've said that this might, have unintended consequences. It might actually harm the people that are meant to be protected. I don't think that that's right, at least because here, unlike in prior efforts to reform the statute, you have a chorus of support among civil rights organizations. And it's kind of like gaslighting to say that they're not the ones that would benefit. The other is I'm very happy to see that there's a carve out or an exception for paid content. This is actually what is most troublesome about the way in which the immunity has changed, or hasn't completely responded to the changes over time. This is material that intermediaries are deeply complicit in developing by design, right? So and they do it pursuant to their commercial interest in collecting user information, and so that the bill recognizes this is very important. I think we can talk more about whether this reaches further than it should. I'm happy to have that conversation. And you asked pointedly, and I think rightfully, Issy, this question. It's a good question to ask of Senator Warner. I'm not as worried about it to the extent an Amazon Web Services or a hosting service is actually part of the supply distribution chain of harmful or unlawful content. They should be second guessing the support of that content. And I want to amplify a point that Marianne just made. And there's such an important innovation here, and this is the distinction between innovations, information and speech. These are intermediaries that traffic in unlawful speech, right? And we might call this unlawful content online. Advertising on the basis of race or gender in certain markets is unlawful, right? So I'm very happy to see that, and I actually think I've spoken a lot. I'm happy to say more.
Well, I appreciate it. It was all interesting. So never too much, Olivier. But I do want to turn to Daphne, because I know not all of our panelists are totally enthusiastic about the Safe Tech Act, and that might put the spotlight on you, Daphne. What are your concerns with this bill?
Sure. Well, I mean, I think as a starting point, if one of the selling points of a bill is that Facebook might like it, that in itself might be reason to examine it more closely and to ask whether other approaches that hit major incumbents' bottom lines harder, like approaches grounded in privacy or competition, might be what we should be looking at instead. But with the Warner bill, my main concern is just its imprecision. It tackles 5 or 6 different problems at once and tackles each of them with maybe one sentence of legislative language. And they are all big, hard, complicated issues, including the very important issue of enforcement of civil rights laws online. And the problem with using very loose legislative language to go after these things is that the laws that make platforms liable for user speech are really levers, in the physics sense. You put a little bit of power in and get a lot of power out. So whatever the law tells platforms they should take down, their incentive is to go way beyond that and take down a big margin beyond what the law requires. And they, consistently we see people and companies using this leverage to get platforms to take down speech that shouldn't come down, to take down critical reporting, to take down criticism of religious organizations, and so forth. Which is why it's so important in crafting platform liability laws to do what the PACT Act does and to do what the pending Digital Services Act in Europe, in the EU does, which is to try to put a whole lot of procedural restrictions in place to prevent that over removal, prevent that leverage that causes these platform liability laws to have a much bigger output than the drafters maybe initially intended. And so that's where I think it is unwise and will lead to very significant unintended consequences to try to, take on a problem like civil rights enforcement or a problem like misuse of advertising with a sentence or two in a law like this, rather than to really go deep into trying to solve individual problems and trying to put the detailed rules in place to get the consequences that lawmakers are actually seeking.
Lauren, I would be interested in hearing what Twitter is saying about this legislation. Like, what does the bill get right, do you think, and what does it get wrong from your company's point of view?
Well, I'd like to put a pin in that. I promise I'll get back to it. But in terms of Section 230 reform, of course, we have a lot of proposals, a lot of ideas right now. And I think, as industry, as lawmakers continue to talk through and really identify because I don't think we're completely aligned in terms of what is the problem we're trying to solve. And so, the problem that we've identified, no regulation, is that we have a major trust deficit, not just at Twitter, not just the tech industry. We also have a trust deficit when it comes to our institution at large. So we really sat down and examined how do we build trust, and we put forth 4 principles that we think will go a long way in getting there. The first is transparency. We know we have a lot more to do to be more transparent with our users about the actions we take, our enforcement of our rules. The second is procedural fairness. As we continue to especially use technology more and more as we engage in content moderation, we do need a backstop to make sure that if we do make a mistake, because we will make mistakes, that we correct that mistake. The third is user choice and algorithmic choice. We believe that empowering users to have more controls over these tools, it's going to ultimately result in better outcomes. And the fourth is user privacy, of course. And so we look at all of these through a human rights framework, by the way. So the thing that I think that lawmakers need to always consider when they're looking at these solutions is competition, because without competition, obviously you entrench the largest incumbents, but you also, without competition, you're limiting our ability to innovate in these areas, because we all, in order to kind of move the ball forward, to be better at enforcing our rules, we have to have that space and that flexibility. And so that's how we're approaching Section 230 reform generally at Twitter. And when it comes to specific proposals, we're engaged in those conversations, and we really, really want to work with anyone who's looking at solutions.
So because the Safe Tech Act doesn't necessarily hit those 4 points, or might in certain ways, do you back the parts of the proposal that align with your framework at Twitter, or how exactly are you approaching those conversations?
Yeah, absolutely. I mean, we've had conversations, and I don't want to get too specific into bills here, because I think that, some of those conversations, I want to reserve those with staff. But, we want to make sure there's room for competition and innovation. And I think, we have some conversations to have in the coming weeks around this bill.
Okay. Marianne and Olivier, because you guys went first, I wanted to give you a chance to respond to some of the concerns that Daphne voiced about the Safe Tech Act and its sweeping nature, or any of the concerns she voiced. Marianne, do you want to start?
Sure. And without necessarily tying this to the specifics of the Safe Tech Act, because you hear some of the same complaints about essentially any meaningful reform of Section 230. There's always this concern about over-deterrence, which, in the free speech context is sometimes referred to as the chilling effect, the idea that it's not just the regulations, but it's the attempt to preemptively accommodate those regulations, that's going to mean that all these companies are going to get extremely conservative about what they leave up. And I just think that that's kind of, it's one of those points of dogma, I think, that we really should question a little bit. Platforms, especially for-profit companies, have lots of incentives in terms of what's going to help them decide what they're going to keep up or keep down. And they're making all those decisions all the time, even with Section 230 in place. And so I think that there's a tendency to rely on this intuition that, if there's a law coming, all the companies are going to respond the same way. They're going to take down massive amounts of content, and it's going to be a disaster. I think that's truly an empirical kind of claim that we should treat with some skepticism. The other thing I want to make sure we understand is that there are slippery slopes in both directions, right? The status quo is when you don't have any regulations and you don't have any incentive to care about the consequences of your reckless or negligent practices as a company, that means that you are leaving aside all the abuses and the injuries and the harms that are actually today something we can see and measure. So when we're concerned about saying, well, there'll be this change in the way that companies make their decisions about what to leave up, the answer is obviously yes, because the only people who would oppose that are people who think the status quo is as good as it could ever be. And all the injuries and harms that flow from that are it's just the cost of doing business. It's just the cost of the internet. And I think too, it has a tendency to rely on a fairly simplistic notion of free speech, even. That what we know from what a lot of these platforms have allowed us to see is that when you allow just a rampant harassment and intimidation and slurs and threats, you don't get more speech, you get more of that speech. But what you also do is you drive off people from your platforms and you force them to essentially drop out of civic participation. People can't speak freely when they're being threatened, when their children are being threatened, when their private information is being published without their consent. So we have to talk about the speech consequences of regulating or not regulating. And we know what a lot of the harms are right now with this very laissez-faire approach to regulation. So I think it's really important to be a little bit more nuanced about that approach to what would happen if there were just a few more restrictions on what companies could do. And I also want to think about how this distinction between what the big companies can do and what the little companies can do. I think it's always helpful to think about how, in a sense, we're talking about the internet and the tech industry as if it should be completely exempt from all of the hard questions that every other industry has to deal with. That is, there are small companies in every business you can think of, and we still require them to have certain safety mechanisms in place. We require universities and workplaces to adhere to anti-discrimination policies. We enforce at all times a concept of collective responsibility that says if you're in charge of an environment, if you're making money off of it, that comes with certain obligations about what happens on your premises and what happens when you let sexual harassment go by without dealing with it. So that's every industry, right? That's every place, except for the things that happen online. So the question should really be, why have we thought that the tech industry deserves that complete exemption from all those hard questions, as opposed to saying they have to deal with it the same way that every other industry has to deal with it?
Thanks. So, and I just wanted to go to Olivier and see did you have any follow-up in response to what Daphne said or what Marianne said?
I do, and I want to hit home this point about nuance that Marianne makes. We do not have nuance in this area of law because of the exception. This is the area of law where we do not. And the reason we don't, to amplify a point that Senator Warner makes, is that these cases were by design, and their strongest advocates, to stop litigation at the motion to dismiss, where we never actually find out how implicated an intermediary is. Just to be clear about this, we might actually have disagreements about whether an intermediary is illegally complicit in civil rights violations or cyber stalking. We might have disagreements about that. And I actually might agree that in some cases they're not. But we actually never get to that question. We don't have nuance in this area. There is a motion to dismiss effort here that, by the way, these companies file pro forma until they're pushed back by journalists or civil rights groups. So this is not a minor point. This is an extremely important point in this context. I also want to address the concern about amending statutes by sentence to sentence. There are no limits to the number of laws in the US Code that are written by sentence to sentence. And the most powerful ones, in fact, are the antitrust statute and the consumer protection statutes under the Federal Trade Communication Act statute. So that's important. And finally, I just want to speak to this concern about hampering innovation and competition. Under no circumstances do we think that a company should build a defective product in furtherance of competition and innovation. We don't do that, right? We don't believe that a company should start and discriminate among its employees or commit harms among their employees, because we have baked into the US Code these norms. These companies have eluded this kind of legal scrutiny for too long.
Thank you.
So Daphne, you've written that the PACT Act has problems, but it's talking about the right things. So first, briefly, what are some of those problems, and why is it on the right track to you?
Sure, and this goes to the question of whether a good change is a one-sentence change or, as I think it is, and this is much more tedious, a 5-page change. The international human rights literature on platform liability, which goes back 10 plus years, there's great work from the Inter-American system, for example, on what a human rights compliant framework should look like, is really emphatic about things like, if you're going to put liability on platforms to decide what content to take down, then you should have processes in place so that the person who has been silenced knows and has an opportunity to appeal. And so people who send bad faith allegations can be penalized for doing so. And, for difficult legal judgment calls, you can have courts make those calls instead of having risk-averse platforms make the calls. There are a bunch of just process things, tedious but important process things that function a lot like civil procedure does in a court, that can help reduce the collateral damage from platform liability laws. And so when I say we need something more detailed, that's what I'm referring to, is this thing that is evolved, outside the US, places that haven't lived in the shadow of CDA 230 for the past 2 decades. They've worked toward recognizing how important these systems are. And that gets us back to the PACT Act, which is all about recognizing how important these systems are. And so it has things like public transparency reporting about content takedowns. It has clearer processes when platforms enforce their terms of service to set forth clearly what the rules are and to have appeals for the users who are impacted by them. It has things like allowing people who have been harmed by unlawful online speech to get court orders and bring them to platforms and say, hey, a court has ascertained that this is illegal. Now you have to take it down. Which, by the way, I think might be what the injunction provision in the Warner bill is getting at. And I think that is one of the most realistic possible ways forward, is finding ways to harness the power of courts. And so that's what I find most interesting in the Warner bill. That said, the PACT Act, was drafted by people who have not themselves, sort of been in the trenches doing the work that trust and safety workers do and that moderators do. And so I think there are just a lot of pieces in the details that would improve with the experience of people who've, tried, for example, operating phone lines as opposed to receiving complaints via web forms for takedown requests, things like that. So I think there are details that definitely could stand improvement. And I worry somewhat about just the overall weight of the obligations and how that will fall on the smaller and mid-sized platforms that are in scope. But because it leans on process rather than on simply stated standards that are then, outsourced to platforms to interpret for themselves, I think it is coming from the right place.
Lauren, I want to follow up with you, actually. So we're talking a little bit about effect on somewhat smaller platforms. Twitter's obviously not small, but it is smaller than the biggest companies. And I hear you, and I hear in Twitter's messaging, you want 230 reform that doesn't harm competition, that doesn't create greater burdens on smaller companies that the biggest companies can withstand. I wonder about the specifics. Like, how do you do that? How do you change 230 in a substantive way, in a way that, as you said, addresses human rights without creating that undue burden on, any kind of smaller platform? Like, can you get us into some of the specifics of how that works? What's different about your stance versus like Facebook and Google?
Sure. And I think, Emily, you just hit on the $1 million question. That's why we're all here today. And I think generally, 90% of us kind of have similar ideas in terms of like where we want to go with these things. But in terms of what the problems are and what we want to solve for, I think the sticking point is how you get there. I think what Daphne said around process is really critical, because as technology practitioners, you have to be able to scale things and implement them. And so focusing on the process side of things, I think, is absolutely critical. One thing that people have talked about in the 230 debate, I know Marianne's talked about it quite a bit, is the duty of care model. That's something that's a popular concept to discuss when you're having the 230 discussion. Aside from the actual regulatory piece, we have looked at, as you mentioned, other industries have had to self-regulate or come up with a set of standards for their industry. And so we've, for several years, been tinkering around with different institutions and different folks who've been trying to do this. And most recently, we launched with several tech companies the Digital Trust and Safety Partnership, which is a set of industry standards for trust and safety processes. And so we're really excited about that particular project, and we'll continue to invest and see where that goes. I'd encourage people to take a look at that. And so I think that that's, in tandem with talking about regulation, that's certainly an effort that's underway. And then the other thing I would just say is going back and looking at how we arrived at Section 230 in the first place. It was a lot of the fundamental basic questions around who's liable when someone speaks and what are the values that we have. A lot of this has already been litigated, and that's what led us to Section 230 to begin with. And so I think a lot of the fundamentals around online speech are the same as they were in 96. I think at least where Twitter is we think we should build upon that. And I don't think we necessarily need to erode the basic fundamentals that are in place. So, we're looking at all the proposals right now. We're solutions focused. We'll talk to anybody about their solutions. And we're looking forward to the debate this year, and we want to be part of it.
Great. Well, Daphne, I wanted to offer you the last question because we have asked Senator Warner about the critiques of his bill, but I think it's only fair to ask about some of the criticism that that people who are Section 230 defenders often face. And one line of criticism I hear is that people who don't want anyone to touch Section 230 haven't necessarily adequately explain the values judgment that they're making, which is to say that if on one hand, reform to Section 230 could hurt businesses, that is a bad outcome. But on the other hand, under the status quo, Section 230 enables all kinds of online harms, illicit gun sales, or Senator Warner was talking about the Grindr case, which is sort of infamous, and people's lives are being ruined. And that is an obviously bad outcome. And so the question I often hear is, well, for the defenders of Section 230, there's a trade-off either way. Why do you choose one over the other? Why do you take the stance that you take? So I'd love to hear your thoughts on that in the remaining moments we have.
Sure. So I think part of the problem is that a lot of the online speech that does harm is legal. For better or for worse, the First Amendment permits hate speech. It permits all kinds of misinformation. It permits, sharing horrific things like the Christchurch massacre video in many contexts. There's just this very broad swath of content that I think most of us find abhorrent and don't want to see, and that most big platforms want to take down, but which is legal. And so Section 230, was crafted. It wasn't intended entirely to be a, pro-free expression, anti-censorship bill. It was crafted to ensure that platforms could take that stuff down and could do that without exposing themselves to greater liability from plaintiffs who then said, oh, you now count as an editor and you're liable for whatever you missed. And so I think as we try to do this calculus of what rule prevents the most real world harm to real people, and what rule has the, what consequences for speech or innovation or these other sort of values that are in the bucket. I don't think anybody actually has the information to calculate what rule does the most work to prevent real world harm. Precisely because CDA 230 is enabling a system in which a whole lot of removal of lawful but awful speech is happening because of CDA 230. And that, this is kind of an indeterminate answer, but I don't think there is a good way to know which rule ultimately favors harm prevention more.
Okay, Marianne, I saw you, have a little bit of a reaction there, so I will just end on you. I don't want to leave anything unsaid.
Thank you so much. I did have a reaction to the idea that CDA 230 is what is allowing these companies to take down content. Two things. One is that the First Amendment is really what allows these companies to take down content. Section 230 is a procedural matter. It's not a substantive matter. These companies have the First Amendment right to take down whatever they like, and they have been. It just so happens that much of what they have been motivated to take down has not been the kind of material that is actually damaging people's lives and ruining their reputations and causing severe civil rights harms. And so the idea that the industry just needs to regulate itself, that the rule that was established in 1996 is the best rule we can do. Most of our laws that most of us have had to deal with in the offline world was established before 1996. This is a really young law compared to that. Principles of collective responsibility, the idea of civil rights altogether, the notions of what is and isn't protected by the First Amendment, which is actually, I would suggest, a bit more complicated than maybe the idea that hate speech is protected. Some forms are and some forms aren't. That's an extraordinarily vast, complex area of law that in 1996 effectively was upended for the internet. And the question is whether that has been good. Has it actually made us more free? Has it made us more informed? Has it made us more equal? Has it meant that marginalized populations actually do have a better chance at expressing themselves than not? Those are the kinds of questions we can be asking, should be asking. And if we are telling ourselves that this world of insurrections and vaccine misinformation and online hate and intimidation campaigns are the very best that we can do, and there's many of us who just disagree that we can't actually do better.
Well, I really appreciate you all coming on to have this conversation. And obviously, it's not something that we were going to solve in an hour, but I really enjoy hearing everybody's perspectives. And I appreciate everybody who's watching at home for tuning in. So thank you all for joining us.